Special Counsel Jack Smith's office has responded to former President Donald Trump's request to delay the Mar-a-Lago classified documents case. So last week, Trump's legal team asked District Court Judge Eileen Cannon to reschedule the trial from May until after the 2024 election so that, let's be honest, he can probably pardon himself after he wins. Assuming, of course, he does win. Now, they claim, of course, that prosecutors failed to turn over documents as part of discovery. That argument, as Smith laid out, is complete and utter crap. So, first of all, those documents were very classified, okay, very top secret, and so much so that they couldn't be stored in Florida, but had to be moved to Washington, D.C. because, well, there wasn't a facility secure enough to house them near where the trial was taking place. So that's, again, what the Trump team is saying. Now, these documents, by the way, are, the ones that Trump allegedly had sitting around Mar-a-Lago. And so it's kind of interesting that their argument is, well, I mean, they're so top secret. I mean, the stuff that Trump had, like, in his house, they were so top secret that you can't even view them here near the trial. And so I guess you're going to have to push back the date of the trial. Sorry, but, we have to have access to those files. And we got to go to Washington, D.C. to just to look at them. I mean, because they're so top secret. But anyway, client totally innocent. What? It's almost unbelievable, except that it's totally believable. All right, so now, of course, Smith's team responded to this, and here's what he wrote. The defendants provide no credible justification to postpone a trial that is still 7 months away. They are fully informed about the charges and the theory of the government's case from a highly detailed superseding indictment and comprehensive, organized, unclassified, and classified discovery. Their unfounded claims of government non-compliance with discovery obligations do not support their request. So again, the other really funny thing is they're saying the government is not compliant, whereas Trump is being charged with not being compliant with the government's request to return the documents. So we're not, we're not non-compliant. You guys, you're not compliant. It's a he said, she said game. That's what they're playing. It's bizarre. But yet, while they're playing checkers, here you got Jack Smith playing chess. But as I mentioned, as I'm going to mention here, playing chess might not work if there's somebody who's going to flip over the board. And this time it won't be Trump. I'll explain that in a minute. But first, let me go on here and give you another quote from Smith's team. Quote, their claims about their inability to review classified information are distorted and exaggerated. And in any event, the government expects the classified information security officer will resolve any remaining issues this week. There is no reason to adjourn the trial date. The defendant's motion should be denied. So now prosecutors say that they provided classified materials and evidence to Trump's defense team as required by law. Again, that's what discovery is about. They also say that a sensitive compartmented information facility where you can view those documents had already been provided at Fort Pierce, Florida courthouse where Cannon presides. So there is a special room where you can view these documents that were so secret that they weren't supposed to be in Mar-a-Lago in the first place. They go on to say that it's not so much now the documents themselves that is the issue here. Yes, that is an issue, but they're pointing at this being more of a case of it's Trump's intent to withhold these documents. It is Trump's actions in withholding these documents. That's what really matters. That's the crux of the government case against him. Now, the fact is, prosecutors wrote, that the great majority of allegations in the indictment, including allegations of the defendant's conduct, knowledge, and intent, turn on evidence contained in the unclassified discovery, not the much smaller set of classified discovery. That the classified materials at issue in this case were taken from the White House and retained at Mar-a-Lago is not in dispute. So, right. In fact, Trump's was going around saying, these are my documents. Yes, I took them. They belong to me. They're actually mine. Well, okay. Well, now you can't make that argument. That's contrary to that. So yes, it is not in dispute because he says these are mine. All right, but they're not. Now, furthermore, here's what the prosecutors wrote. What is in dispute is how that occurred, why it occurred, what Trump knew, and what Trump intended in retaining them. All issues the government will prove at trial primarily with unclassified evidence. So they don't even have to use the classified stuff. Now, whether the highly classified documents Trump retained at Mar-a-Lago contain national defense information is a fact that Trump can try to dispute, but will hardly be the centerpiece of the trial. So, again here, regardless as discussed below, none of the defendants' claims about the availability of classified discovery justifies a continuance. They end that with. So, okay. Look, Trump's defense is focused mainly on, I had a right to have them because they're mine and I declassified them. No, for one, of course, that's not true. He didn't declassify them. In fact, there wasn't an order to do so. And if there was, it wasn't at a time where he actually had the power to do it. So, secondly, the documents still belong to the government and not Trump, which brings me to the third point, and the most important point, the case that the government's actually making. The government asked for them back, and he refused. That's it. They were there. It was the government documents, and Trump said no. No, they're not. I disagree. Oh, well, that's fun. Like, you can't, like, disagree on that one. That's not a point of opinion. Okay, they belong to the government. Therefore, you should send them back to the government if they ask you. Okay, but he didn't. He stonewalled the effort in getting them back, told his lawyers, the staff, to lie on his behalf, and tell the FBI, we don't have them. We don't have what you're looking for. I'm sorry. They're just not here. They're just not here. And so he's charged with the Espionage Act, remember, because he willfully withheld national defense information. And according to Smith's case, he allowed people who were not authorized to see that information and to have access to it, like, for example, an Australian billionaire. So his team's argument doesn't make a lot of sense for multiple reasons, and it's just wrong. But at the end of the day, getting back to what I said about flipping over the board, well, it doesn't have to make sense because Trump just happens to have Judge Eileen Cannon presiding over the case. Eileen Cannon has already been doing him a ton of solids. In fact, on Friday, Cannon issued a ruling temporarily delaying a previously set schedule of deadlines stretching from October to May for the Justice Department to make classified documents available to Trump's lawyers and for the defense team to have time to review them. This is indefinite, this delay. And it comes after Trump's request to delay until after the election, which again, he could pardon himself, right? And that's the fear. Now, Cannon has yet to rule on Trump's motion to move back to trial, but this, again, really does make it look more likely that she could delay it long enough to help him theoretically escape these consequences, which is exactly what he's looking for, exactly why he's asking. So when it comes to the facts, Smith is correct, but that still doesn't mean, unfortunately, doesn't mean that Trump won't still get what he wants because of the fact that he has a very Trumpy judge